Bonjour, everyone. Welcome. This is Jill Dorfler from Zaagi Bagaang. You're here with us live. I know it takes a minute or so for everyone to get logged on, so we'll give you time to get connected. As you do get connected, if you say hi to us in the comment box, that helps us know that the feed is going and that things are running smoothly from our end. So you're tuned into our Get Informed, Get Involved Watch Party series. This is the fifth session in this series, and we are doing this through the Zaagi Bagaang project. Many of you have seen some of the series already and know about Zaagi Bagaang, but I like to just read the mission statement just as a reminder for us all. Zaagi Bagaang is a grassroots effort focused on governance and nation building. With our Anishinaabe teachings and values guiding us, we bring our gifts together to provide information and to work towards Minabamadiziwin today as well as for the next 7 generations. And so what we've been doing as a part of this group is available, some of it's available on our Facebook page, and then we also have the zaagibagaang.com website, which has a huge amount of information, both documents and resources, as well as the other live sessions that we've done, and also a series of short informational videos. So please go ahead and check those out as time allows and fits with your interests. So I think we're starting to get some people logged on. We're broadcasting, as we always do, from Fond du Lac Tribal and Community College, and we appreciate the support that we have here from our technical team, putting all of the behind-the-scenes efforts to get us on the air for the show. So thank you so much to Liz Jacola, Jeremy, and the whole team that's behind the scenes here, getting all of our technology up to speed. So the title for our session today is An Introduction to the Minnesota Chippewa Tribe Constitution. We've had a variety of topics on our live sessions, starting out with our teachings and our values, historic look at governance, and then in our recent session, a little bit of a look at the formation of the Minnesota Chippewa Tribe. And so today, we're going to delve into a little bit more detail on the Constitution itself. And we know that some of our viewers have probably read and studied the Constitution many times, while as some of our other viewers maybe haven't read the Constitution or have only seen sections of it before. And so our purpose today is just to provide some basic intro information and then also take your questions as we've done in the past. So in a minute here, I'm going to turn it over to our guest, Phil Brodeen. What he will do is present a short summary for us, some of the highlights of the Minnesota Chippewa Tribe Constitution. He'll do that for about 15 or 20 minutes, and after we get through those highlights and a little bit of background, then I'll be taking your questions. So as you're thinking of questions as we go along, put them into the feed, and we'll get to as many as we can before we wrap up about 6:30 or so. So I think with that, I will say miigwech to Phil Brodeen for taking the time to come up to Fond du Lac and to be with us and to share some of your knowledge about the MCT Constitution with us. So I'll let you introduce yourself a little bit and turn the floor over to you.
Well, hi everyone. My name is Phil Brodeen. I'm a Boys Fort band member and the current legal counsel for the Minnesota Chippewa Tribe. The current constitutional reform effort began in earnest probably 3 or 4 years ago under the leadership of then President Kevin Dupee from Fond du Lac here. At that time, the TEC Tribal Executive Committee made a concerted effort to focus on constitutional reform. It's important to note that constitutional reform specifically for the Minnesota Chippewa Tribe isn't a new thing. It's been around since pretty much the Constitution was initially enacted in 1936. I know that when my grandfather was on the TEC from Boys Fort, That was in 1988. They were discussing it then, and it's always been at the forefront of the discussions for the Minnesota Chippewa tribe, and for good reason. Before really getting too much into the nuts and bolts of the Constitution, I think it's important that we focus and have a good understanding of where we've came from. It's my understanding that a bit of that was covered in the previous video, and for those of you who have heard this before, I apologize, but I think it's very important that we keep stressing on how we got here before we can really start thinking about how we're going to move forward. Before getting into the development of the Constitution, we need to talk about 3 federal laws that principally shaped the way that the Minnesota Chippewa tribe was initially composed. The first is the General Allotment Act of 1887. I can hear your boos through the Facebook Live feed, and for good reason. The General Allotment Act brought about a lot of the ills that we're facing today with regard to land tenure. The General Allotment Act tried to change the communal nature of our lands and societies and make us agrarian, make us farmers. It accomplished that by allotting land to each head of household. Unfortunately, one of the main things it did was not provide for the future. So once the initial allotments were made, the surplus lands at that point were sold or given away, which really created our fractionated reservations that we know of today. The idea was that individual tribal members would receive allotments and then become farmers, but that didn't really take into account the need of the future generations. So that's something that really led to where we are today and how we got organized the way we did. It led to the disposition of millions of acres of Indian land nationwide. The next thing to mention, the next federal act, is the Nelson Act of 1889. Nelson Act essentially functioned like a mini general allotment specifically related to the Anishinaabe in Minnesota. So the Nelson Act incorporated a lot of the General Allotment Act's principles, and also it tried to get us to relocate, all of the Anishinaabe in Minnesota, to relocate out to the White Earth Reservation. Similar to the General Allotment Act, it mandated the allotment of lands here in Minnesota, and it focused on all of the Anishinaabe in Minnesota, including Red Lake, which is interesting. One thing to note is that Red Lake opposed being included in this kind of larger group and successfully succeeded in maintaining their separate, distinct tribal government structure that was later validated. Their separateness was validated in a Supreme Court case in the mid-1930s. One thing that the Nelson Act also did was create a fund, the Chippewa and Minnesota Fund. The Chippewa and Minnesota Fund is partly, you can trace our structure of the MCT back to the Chippewa and Minnesota Fund. So what it essentially did was create a fund in which money and proceeds from sale of surplus land, as well as timber resources, went in there for the benefit of all of the Chippewa in Minnesota. That really forms the basis of our government as it existed in 1936. Then the next important act to cover briefly is the Indian Reorganization Act. It was two-pronged. Firstly, it stopped the allotment of land, and then secondly, it imposed a standardized structure or model of governance on a lot of the different tribes. When I say imposed, it was mainly driven by the Indian offices at the time and the Bureau of Indian Affairs were pushing tribes to reorganize in a structure that they could recognize and deal with. And that's something that was likely foreign to a lot of our ancestors when we talk about centralized decision making and relying on individual people to make decisions. So that's something that we've been dealing with as well. So the initial organization of the MCT, the Anishinaabe in Minnesota, as I said, were scattered throughout the northern part of the state. My people, we are originally from the Burnside Lake area, which is across the boundary waters from in near Ely. The bands lived in fairly independent communities that often scattered. We would often get together in communal events around the different seasons. There was no real centralized tribal organization that made decisions for the rest of the people. You'll see this in the treaty making time. Oftentimes, I think one of the treaties, they were entering into a land cession in northeastern Minnesota, and a bunch of different Indian tribes showed up, or groups of Indians showed up from different bands. That led to later treaties in which they would segregate the individual bands that they wanted to deal with and bring them to Washington instead of having big treaties around Fond du Lac or over in Wisconsin. So that's something important as well. The initial reservations were set aside for the individual bands of the Anishinaabe. As I said, the Nelson Act created the Chippewa and Minnesota Fund. I see the Nelson Act as a way to ease administration for the Indian office, to attempt to deal with the Anishinaabe who they had to manage funds for. Instead of treating all of the little groups as individual entities, they grouped us all together, and that really shaped how our initial IRA Constitution formed in 1936. On that point, our Constitution has went through, I like to separate them into three different kind of periods. The first is the initial organization in 1936. The second is the amended and revised Constitution that was divided in 1963. The third is the amendment eras coming from roughly 1972 up to present. And by amendment, I don't mean comprehensive amendments. There were 4 distinct amendments that went for secretarial elections. The initial 1936 Constitution was passed shortly after the passage of the Indian Reorganization Act. Significant discussions occurred on whether the people of the Anishinaabe of Minnesota should organize individually or separately. The Indian office at the time saw only further difficulties with dealing with all of us if we organized separately, so they kind of grouped us all together into a centralized form of governance. The 1936 Constitution was drafted by Leech Lake member and Indian office employee Jacob Minnell and Cass County Attorney Edward Rogers. It included a consolidated government structure based on tribal communities and districts. It called for the creation of separate charters for each of the 6 individual reservations. A lack of follow-through on the charters and a real individualization of those charters led to the revised and amended Constitution in 1963. That's something we'll discuss later. The initial Constitution was interesting in that it didn't have the TEC as we know it today. Currently, the TEC is organized of the Secretary Treasurer and the chairperson of each band of the Minnesota Chippewa, so we have 12 representatives. The 36th Constitution had a more representative form in which individual districts and wards on the reservations were separated. Then 2 members were delegated from each district, and then those members from each of the reservations would elect or select their tribal delegates to send to the Tribal Executive Committee. There were approximately 32 precincts at the start, which resulted in 65 or more elected officials. One important thing to note in the 1936 Constitution is that there's a lot of controversy on whether the idea of centralized decision-making was truly accepted by the representatives at that time. It's important that we look back at kind of the contemporaneous statements at the time and see what was said at that time. And the one that comes to mind is from a memo, and I apologize while I read this, but it's important. It's a memo from Indian Agency personnel Zimmerman to Burns. It states, with regard to the topic of centralized decision-making, it says, "We understand from the representatives who met with the tribal delegates that the tribe does not wish to give the tribal organization power to control the local reservation or community organizations, and wishes to leave these local organizations free to operate in an independent way. So the answer in the 36th Constitution to provide that independence and localized decision-making was these charters. The 36th Constitution was ratified by the MCT on June 20th, 1936. The votes were roughly 1,500 for, 500 against, and then it was approved later on in 1936 as well. The BIA had a strong influence in drafting the initial Constitution, and once governance under the Constitution started, it became apparent that there was little in the law that would allow for or directly relate to localized control. The Indian Agency, the way it was pitched was that each of these local charters of organization would help provide for that localized control. However, the charters never got specifically tailored to each group so that they could be workable forms of governance. Opposition to the 1936 Constitution was almost immediate. Some argued that the folks who drafted it were merely pushing ideas for their own benefit. Some stated that the local Indians didn't truly understand what they were agreeing to, and this led to, by 1945, 3 reservations. 3 out of the 6 wanted to leave the central government due to a lack of local control. As we talk about the constitutional reform process, I think that, as I'll talk about later in the duties of the Tribal Executive Committee and the duties of the Reservation Business Committees, there's not a clear separation of or a real distinction between the duties. Often those provisions repeat and mirror themselves, so it's difficult to really distinguish what the TEC is responsible for and the RBCs are responsible for. I'll briefly discuss that later. The revised 63 Constitution is largely the document that we're following today. It was enacted in 1963 and approved in 1964. It accomplished a number of things. First of all, it removed the local charters. It created the Reservation Business Committee system, which allowed for greater local control. It implemented a quarter blood degree quantum, and it changed the term of office from 1 to 4 years. So this is largely the Constitution that we're currently under, except for 4 amendments that I'll briefly discuss later. The first part of our Constitution, it's actually the Constitution and bylaws. The Constitution governs a lot of the rights and duties of Minnesota Chippewa Tribe members and the Tribal Executive Committee. And then the bylaws talk about more procedural things and the duties of the officers of the Minnesota Chippewa Tribe. Article 1, the organization and purpose. So the stated purpose is to conserve and develop tribal resources, promote general welfare, preserve and maintain justice. Article 2 of the Constitution deals with membership. So it includes essentially 3 different forms of membership. One, or I guess qualifications for membership. One would be being listed on the 1941 roll. The second part of membership would be children born between 1941 and 1961 of those who were on the 1941 roll. And then the third one is a quarter blood degree and born to a member. As we'll talk, I think a lot has been made, and rightly so, about the blood degree, and a lot of discussion has been provided, and it's a good topic of what the blood degree actually does to us as Anishinaabe people. And as we go forward with the reform efforts, this is going to be something that's very important, is the membership provisions and that blood degree requirement. The third is Article 3 relates to the governing body. So it provides the structure of the Tribal Executive Committee, the chairperson and the secretary-treasurer from each Reservation Business Committee. And then it creates the Reservation Business Committee for local issues, which typically consists of 5 members. Article 4, tribal elections. It discusses or authorizes us to conduct uniform elections for the positions to the reservation business committees. A lot of what the current Minnesota Chippewa tribe does is relates to elections and enrollment. Those are kind of the day-to-day things. The MCT provides help through funding and things like that, but most of the bread and butter of what they do on a day-to-day basis relates to elections and enrollment. Article 5 relates to TEC authorities, and Article 6 relates to RBC authorities. I'll discuss these in further depth later on, but it's important to note that, as I previously mentioned, the duties often mirror each other, which leads to questions of, well, what should one body be doing and what should the other body be doing? So as reform efforts go on, we should definitely focus on clarifying those and dealing and having specific authorities for each. Article 7 relates to the duration of the Minnesota Chippewa Tribe Constitution. The duration is perpetual in nature. Article 8 relates to majority vote. It states that all elections under the Constitution, a majority vote shall rule unless otherwise provided by an act of Congress. Article 9 relates to bonding of tribal officials. Article 10 relates to vacancies and removals. Vacancies filled on the TEC will be filled on the TEC by the Indians of the reservation which the vacancy occurs. And in the interim, the RBC can select temporary TEC members until an election can occur. It's important to note that a removal requires 2/3 vote of RBC members for removal. Article 11, ratification. It's essentially stated that the Minnesota Chippewa Tribe Constitution would not be operative until ratified by a majority vote of adult members of the MCT, provided that 30% of those entitled to vote shall vote. With the initial adoption of the Minnesota Chippewa Tribe Constitution and this one, it's often questionable whether they were really ratified by the body pursuant to this ratification term. And we'll talk about some of the numbers that, how they can be shaped differently. So Article 12 relates to amendment. This is an important one and one that I would like to specifically focus on and discuss a little more in depth. So Article 12 of the Constitution says that the Constitution can be amended by a majority vote of adult members, provided that at least 30% of those entitled to vote shall vote. A couple years back, I think in 2015, the Bureau of Indian Affairs came out with new secretarial election regulations. Secretarial elections are required in order to amend a constitution. One of the things in the secretarial election regulations that differs from our current constitution is the number of votes that's necessary. So the secretarial election regulations created a process in which by default, the process would be mail-in ballots. So in order to receive a mail-in ballot, one had to register for a mail-in ballot. And oftentimes, the 30% of those who would vote in those would be counted, and it wouldn't necessarily correspond with those who are entitled to vote in a tribal constitutional amendment. This is an important part because under this constitutional language, the existing TEC passed a resolution that stated that in order to get 30% of those entitled to vote, they interpreted those entitled to vote not to mean those who registered to vote pursuant to the secretarial election regulations, but those who are entitled to vote pursuant to being a member of the Minnesota Chippewa tribe. So the numbers went from, you could have passed previously an amendment with a smaller number. There's questions of legitimacy with those, but the TEC made a decision back in 2016 or 2017 that 30% means all of those entitled to vote. This means that we need roughly 11,000 votes cast in the secretarial election for a constitutional amendment in order to successfully amend the Constitution. That's a Herculean effort and would require nearly record voter turnout in terms of what our typical elections for the Reservation Business Committee seats are for. But I don't think we should be discouraged by that. If we get that amount of people to vote and vote in the affirmative, the majority voting in the affirmative, I think that is the most basic and fundamental way in which we can shape our Constitution and really have a voice in where we're going from here. There wouldn't be any legitimacy questions with regard to that process if we got that amount of people to vote and the amendments passed. Article 13 of the Constitution deals with rights of members. It says that members will be accorded equal rights, equal protection, and equal opportunity to participate in economic resources and activities of tribes. No member shall be denied any constitutional rights or guarantees enjoyed by the other citizens of the United States. While we go forward, I think that this particular provision we can do better if we do constitutional reform efforts. We can get more specific in the rights that we want guaranteed by our Constitution and specifically tailor it to our membership and our cultural dealings. Right now, it just mirrors kind of the constitutional rights that are provided to United States citizens. Article 14 deals with referendums. It states that any enacted or proposed resolution or ordinance may be subjected to a referendum vote of all of the TEC members. Upon receipt of a petition signed by 20% of resident voters or by affirmative vote of 8 members of the TEC. The referendum one is hugely important, and if we want to keep getting more input from community members and members of the Minnesota Chippewa tribe, I think we should look at constitutional reform specifically for that one as well and make it easier to have a citizen initiated referendum process. 20% of resident voters might be a large number in which to go around with a petition. And finally, Article 15 relates to the manner of review and specifically states when the Secretary of Interior review is required. I'll briefly just go through the bylaws as well. The bylaws are an important part. It's important to note that if the structure of the Minnesota Chippewa tribe is changed and the officers change, we'd also have to change the bylaws at the same time. So look at it as an all-inclusive reform effort if we go forward with reform. Article 1 relates to the duties of the TEC officers. The current officers are the President, the Vice President, and the Secretary-Treasurer. Article 2 talks about TEC meetings and how those are conducted. Article 3 includes the installation of members and includes an oath of office. One of the interesting things in my time as the MCT legal counsel has been watching the new oaths of office. I think the last 3 words in the oath of office are, "So help me God." And that's often changed by whoever's administering the oath to reflect our cultural ideas and things like that. So it's often stated, "So help me Gichi Manadu." Article 4 is an amendment. Amendments to the bylaws are conducted in the same way as amendments to the Constitution. Article 5 includes miscellaneous things, talks about the fiscal year and when that starts. Article 6 of the bylaws states that the RBCs shall adopt their own specific bylaws. I'll briefly go through the 4 amendments quickly. So there's 2 amendments that occurred on November 6, 1972. The first one stated that all members of the tribe over 18 years of age shall have the right to vote at elections held within the reservation of their enrollment. This brought about a significant change. The operative part of this is within the reservations of their enrollment, so that's where they were tied to voting. Amendment 2 stated that candidates must reach the age of 21 before the election. Amendment 3 and 4 were done on January 5th, 2006. The first one stated that the candidate must reside on the reservation of his or her enrollment for 1 year before the date of the election. And number 4 is a controversial one, and for good reason. States that it essentially includes an election disqualification if somebody ever been convicted of a felony or convicted of a lesser crime involving theft, misappropriation, or embezzlement from Indian tribe. A couple of final things to briefly discuss is the powers and duties of the Tribal Executive Committee and the powers and duties of the Reservation Business Committee. The powers and duties of the Tribal Executive Committee are to employ legal counsel for the protection and advancement of the rights of the MCT, to prevent the sale, disposition, lease, or encumbrance of land, advise the Secretary of the Interior with regard to appropriations, administer funds within the control of the tribe, consult, negotiate, contract, and conclude agreements on behalf of the MCT with a variety of parties. Levy licenses or fees on non-members or non-tribal organizations doing business. Recognize community organizations, and finally to delegate to committees, officers, employees, or associations any of the foregoing authorities, reserving the right to review such actions. It's important to note that the Reservation Business Committee duties are nearly the same as the Tribal Executive Committee duties, with the change being instead of TEC, it says RBC. That's led to a lot of interesting but frustrating problems in terms of who should be doing what and whose authority it is to make decisions in what capacity. Another interesting thing is that the Constitution is devoid of a tribal court. Like the United States Constitution obviously sets up the three forms or three branches of government. The Minnesota Chippewa Tribe Constitution doesn't include that, which has led to issues with, in American law, a lot of the development of the law is ushered in by court cases and case law. So they'll look at the Constitution and then try to apply it to the different questions that arise in everyday activities. That's something we're missing here. So that led to the Tribal Executive Committee adopting interpretations of the Constitution, which essentially function in the absence of case law. And the interpretations will be something that will have to be looked at in a reform effort as well, and separations of powers. That concludes my presentation, I think.
Excellent. Well, that was a wonderful, Phil. What a great listing out of providing us some background and history, as well as a lot of the highlights from the Constitution and the bylaws that we're currently operating under. And acknowledging some of those points where it gets a little bit confusing. So it's not surprising to people when they read the duties of the reservation business committees and they read the duties of the TEC and they say, gee, this seems confusing. I think sometimes just acknowledging that is helpful in moving forward to think about, okay, yeah, it's not just somebody feeling that way. That is in fact caused a number of questions, and probably in an interesting way has allowed the kind of flexibility from the time when the Minnesota Chippewa tribe used to be the primary operator of a whole variety of programs, and then we've seen with the move to self-governance, each of the individual reservations taking over or duplicating, maybe in some cases, some of those same duties. So I'm sure, like with anything, there can be some confusion, but potentially a benefit, or it's been spun in a way that has worked to be beneficial, perhaps in a specific variety of cases. So we're open and ready for your questions. I'll be taking a look and keeping an eye in the comment box and relaying questions to Phil. One thing related to the bylaws is you mentioned that if the Constitution were to be reformed, then the bylaws would have to be reformed. Were the bylaws ever voted on, or how were the bylaws initially adopted? Do you know about that? Or I know some of the history of the Minnesota Chippewa tribe there. We talked about this in a previous session where with Zaagi Bagaang, we've tried to collect a lot of have a historical research, but there isn't a great easy reference where we can find that kind of information. So sometimes it's by word of mouth and what we all know. So I wasn't sure if you knew if those bylaws were ever voted on, or if they were adopted in consultation with the Bureau just after the fact.
Yeah, I think they were included in the 1963 constitutional amendments.
Okay.
That's my understanding of
Yeah.
it. I wouldn't be surprised if they were after the fact added, and then the certification of the constitutional amendments were just kind of pushed back around them. So it's very interesting, but there's no question that they go hand in hand today. If the governance structure changed in one, the governance structure would have to reflect that in the bylaws themselves. Yeah.
Do you think bylaws are something that are unique to, really, my understanding, to American Indian nations? We see lots of other countries that have constitutions but don't necessarily have bylaws adopted in the same way. But is your opinion that, yes, we would have to continue with a bylaws process, or?
Yeah, I mean, the way I look at the bylaws is they're essentially part of the Constitution in that they direct how certain things happen, certain procedures from a governmental standpoint. So I think it doesn't really help to have the separation between the Constitution and bylaws, since it's only in really name only. So it would be better probably if true reform happened to just wrap them all within the Constitution itself and not have that confusing distinction between the Constitution and then what's stated in the bylaws.
Integrate them together.
And the bylaws might be a part of kind of the bygone era of kind of the corporate structure that was trying to be imposed in the 1936 Constitution, where we're talking about governing bodies here, governmental entities. We should be talking about constitutions instead of bylaws or specific tribal constitutions or band-specific constitutions as well. So that's something to note that in the future would be something helpful to, I guess, delete the distinction between the two and really treat them equally.
Oh, thank you. That's great. Related to that is about the original charter. And when the charter was revoked, was there an impact, or basically the charter is revoked at the same time the 36 revised comes in? Yeah,
so I think the charters ended when the RBCs began, essentially in the 63 amendments. So no longer were the charters necessary when the governing bodies of each individual band were going to be the reservation business committees that functioned and made the decisions. It's interesting to note that the charters, I think one of the things I read is that they were going to be specifically tailored to each band or each area. So out west, they were going to be more agricultural, and up in Grand Portage and Bois Forte, they were going to be more recreational. If they had copy and paste back in that day, I would say that all of them were copy and pasted, because they're just about exactly the same when you look at them. So there was really they weren't specifically tailored to each area, and that's something that became apparent. It's also interesting that 9 years after the initial Constitution was enacted, half of the members of the Minnesota Chippewa tribe wanted out. So
well, I think that's maybe partly a reflection of these charters were pushed as, yes, they're going to be tailored to the needs of the individual reservations. And in fact, that was a sort of bait and switch kind of situation where that wasn't accurate. And so it's no surprise that there was a level of frustration that for a lot of people, what they felt had been promised wasn't really being fulfilled.
Yeah, and a lack of local control, right?
Yes. Yes.
I think when we look at our RBCs currently today, I like to think that they're the embodiment of what the initial folks thought about when they thought about local control, right? In they're kind of the what's within their authority to govern is definitely focused on their reservation lands. And that's likely the local control that was sorely missing from the 1936 Constitution, which led to 3 of the 6 bands wanting out in 1945.
Yeah. What about the MCT had a corporate charter as well? And what about the process of that being revoked?
Yeah,
So there's so many things with MCT where there's kind of 2 levels of everything. So sometimes we've just been talking about the charters, the individual reservation charters, but there is also, or there was an initial corporate charter for the Minnesota Chippewa tribe as well.
yeah, so I think it was part of the Indian Reorganization Act where they talked about chartering different reservations or different groups of Indians, and that has largely went by the wayside since we've gotten into kind of the self-governance era. We've done a good job of leveraging ourselves to be looked at as independent government units that are separate from state and federal governments. One thing that the Minnesota Chippewa tribe, I think it's important to note that we have over 41,000 members as the Minnesota Chippewa tribe. We've been able to effectively leverage our membership and just the breadth of our I guess, presence in northern Minnesota to really dictate policy at the state level as well as the federal level. So that's one of the benefits that the Minnesota Chippewa tribe has served over time is been a really good way to get all of us on board with a certain issue and then go forward with it. So that's something interesting that will also have to be considered during reform efforts.
Right. That kind of power in numbers politically, it is very advantageous in the American political system and able to leverage authority and to try to make voices heard.
Yeah, and I think going forward in the reform efforts, that's going to be one of the central issues that's obviously present, is that what do we do under the current government structure, or how do we get this document to really state what we want it to say, right?
Right.
There's a need, and I think it's appreciated that there's a definite need for localized control within the different bands. But also, I think there's still a need to recognize our familial relationships and our broader relationships with each other. I mean, as we continue to intermarry and things like that, we're very connected in that way. And there are reasons for reforming in a way that makes us more separate. There are reasons for reforming in a way that makes us more together, right? So we need to, I think the hardest part, and something that we've always struggled with, is striking the balance between what relationship that the Tribal Executive Committee and the Minnesota Chippewa tribe should play, and what duties and responsibilities should be strictly dedicated to the local reservation business committees, or if that's even what they're called, the individual bands. And that's the whole problem created by that is the lack of really definite delegations of authority in the Minnesota Chippewa Tribe Constitution. So in the federal Constitution, you have reserved rights, and you have pretty much any right that isn't specifically included in the federal Constitution is reserved for the state. And that would have been something that would have been so easy to place in there, and just it would have helped us a lot, and said any right not specifically listed in the Minnesota Chippewa Tribe Constitution for the TEC is reserved for the individual reservation business committee. And that would be we'd be borrowing from the United States Constitution, but that's always something that has really interested me, I guess.
Right, because I think some people think of it maybe as a all or nothing type situation. Either the Minnesota Chippewa tribe stays together or it breaks apart. But I think actually what you're articulating is that there would be a whole variety of options for how the Minnesota Chippewa tribe could stay together, but then decide how to delineate out duties, what powers would be at the local reservation or band level, and then what authorities and duties would remain at the kind of umbrella MCT level. And I want to say we've been fluctuating around between these terms, band, tribe, reservation. These get a little bit tricky and are used in a variety of ways in the federal context. And so we see band sometimes used for individual reservations, but then we also sometimes see tribe used in both of those contexts. And these are all, European political terms for political entities, and we're trying to fit them onto our governing structures, and it's not always a consistent process. But connected to that is a question about if there are other tribes in the United States that have more than one reservation under their governing structure. Are you aware of an example?
And that's one of the difficult things here, is that looking at these issues, there's no other real tribal entity like us. And that's what makes us so unique, but also makes it kind of unfortunate that our Constitution doesn't really reflect that difference or acknowledge that difference. Mm-hmm. It's just a Constitution like the other constitutions of individual tribes located throughout the United States. That's one of the things that I think the Indian Reorganization Act, even though it stopped allotment, one of the things is it forced pretty much systemized form of governments on tribes. And once you get into that system, it's hard to really tailor it to what you want to do with it. So to my knowledge, there isn't another federally recognized tribe that's organized this way. There have been efforts to utilize these intertribal bodies to make positive change. And one thing that comes to mind is intertribal courts of appeal. So the idea has been floated around. It hasn't been strictly adopted yet, but in South Dakota, some of the Lakota, Dakota tribes there often talk about an intertribal court of appeals or an intertribal Supreme Court. Yeah. It seems like that could be something that the Minnesota Chippewa tribe could provide a real value to the rest of the individual bands by serving as a final arbiter of these things with, if it's law-trained judges and or non-law trained judges, really whatever form that takes. But that's something that the current structure lends well to that idea, right? Right.
It would provide a little bit of separation and autonomy from the individual. For people who might be concerned that reservations are controlling court systems, having an intertribal system would move away from that to provide some greater autonomy for the court.
Yeah, definitely.
Yes. In our conversations about the amendment process, you talked about how it would be a secretarial election, and the secretary would call for the election. Beyond that, does the Secretary of Interior have a say, and how has the Secretary recently been responding to tribes that have been doing constitutional reform? So the current Constitution has a number of places that says Secretary of Interior needs to approve and ultimately approve amendments and or changes to a Constitution. What is that process, and what's your familiarity with tribes that have been doing this recently and their experience with the current administration?
Yeah, so one of the things is that it's very apparent through formal and informal guidance from the Bureau of Indian Affairs that they no longer want to be involved with these things. They want to get out of the secretarial approval game.
Yeah.
So to an extent, a lot of what they do is they receive things. They don't necessarily make a decision on them. And, I think gone are the days of really heavy-handed secretarial involvement, which is good. But I've also heard it stated that the Secretary of the Interior serves as a safeguard against the trampling of the rights of individual members. I think there is something to be said about that. The question is there a way we can provide mechanisms in the current document where we wouldn't have to go outside to the United States government to provide that service, but have a different way to keep our elected officials responsible for their actions and things like that. And going forward, I think that's something that the constitutional reform should also focus on, is figuring out a really good way, whether it's comparing other laws or other jurisdictions, figuring out a good way to keep our elected officials responsible, and also a good way to keep them honest and things like that. Because a lot of what we've talked about and a lot of what we've seen up to this point is that the tribal members, band members, they want accountability in their elected officials. And I think the Constitution would be a good way to help protect and provide some of that accountability.
Yeah, excellent. I've seen a couple of comments to that effect in the comment feed here, that there needs to be stronger, clearer provisions when it comes to removal, vacancy, censure. Those types of things should be clearly done and laid out. And I think what some scholars would say who study these IRA-era constitutions would say is that these constitutions in some ways are set up in a way that really allows for quite a lot of if there was an individual who wanted to take advantage of the way that it's set up, that is fostered under this system.
Yeah.
And so I think you're right that under a new system, some checks, balances, some clear processes and procedures could make for a governing structure that's a lot more effective and that's responsive to the people, which is really what a lot of people want and have been calling for.
Yeah, and one of the things, I mean, when I talk about accountability, it just means providing clear procedures, right?
Yes. Yep.
Clear procedures would help eliminate or decrease the gamesmanship that goes on with that can be played in some of these situations, and just makes the what's expected of people and what will happen abundantly clear, and that's kind of what I'm talking about.
Yeah, excellent. Another question here, you explained a little bit about blood quantum, the 1/4 Minnesota Chippewa tribe blood quantum that came into effect in the 1960s. What will happen if we get rid of the 1/4 blood quantum requirement?
Yeah, so I think when you see the trend of tribes conducting constitutional amendments, a lot of them are going away from the blood quantum requirement. Blood quantum is problematic. I'll say it as a band member and the legal counsel for the Minnesota Chippewa tribe. Just the globalized and very, how the ease of travel currently today, it just makes it hard to expect our band members to continue to proliferate amongst themselves to keep the blood quantum relevant, I guess. So I would say that that's a definite issue that needs to be addressed and looked at. We need to ensure that our cultural ties and who we are as a people remain present in our membership. But that doesn't necessarily mean requiring that the person is a 1/4 Indian blood. There are other ways to do it, and we need to look around and find a better way to really figure out who we want in our membership, who we are as a people, and what makes us that way.
Right, yeah, I think this is the big question. We know that blood quantum is a fictitious idea that was created out of eugenics in the late 1900s, and so even though people think of it metaphoric today and connected to culture, as you said, culture is something that's lived, that's passed on, that's not measurable by this historic idea of blood quantum, and trying to create a citizenry that's ethical and responsible, that's following our teachings and our values. I think that's what people want, and some of that can be done, in my opinion, in a governing document, but then a lot of that is our responsibility as individuals and community as well. So
Yeah. And
these things kind of dovetail together. You want a governing document that reflects and enacts culture and values, and then the people need to continue to do their part on that side as well.
Yeah. And I think blood degree that's given to us and shown on our tribal IDs and things like that, that's a poor indicator of who we are as people and what it means to be Indian, what it means to be Anishinaabe. I think we can do better and get more creative and really focus in on what we as a people want. And that's one of the things that I think one of the studies that was done is that while populations are increasing incrementally, our population will start decreasing after a certain point due to the blood quantum issue. And that's something that we have to be realistic about and address head on with these constitutional reform efforts.
Good point.
And I talk about these things. I'm kind of flipping between being a Boys Fort Band member and the legal counsel of the Minnesota Chippewa tribe. So take a lot of this with a grain of salt. I'm definitely interested in constitutional reform. So when I say things like that, I'm more talking as a Boys Fort Band member and somebody concerned about our future.
Excellent. Yeah, we appreciate your expertise as attorney, but you're not here in official capacity. You're here volunteering tonight with us, which we appreciate.
Yeah. And that's what makes kind of my job, being tribal attorney, a bit difficult in that when we talk about constitutional reform, I'm really, really passionate about ideas and legal concepts and things like that. But we need to figure out, and I think the TC has done a really good job thus far in not being too involved in the process so as to have a chilling effect or make it seem like the delegates that are currently involved aren't putting in really hard work and having kind of this organic process in which they propose amendments. So the involvement of the TC thus far and me as the tribal attorney has been limited once the actual constitutional convention got started. And it's not because we don't care, it's because we want the delegate process to really work and have these ideas formed for the first time in the constitutional convention meetings.
Excellent. We're going to have time to squeeze in another question or two here. I know also that we're doing a drawing on the other side, and so pretty soon I'll be provided a little bit of information about that, and we'll get to that. Before we do that, we know that in the U.S. government system there are some things sort of reserved for tribes, and so the Minnesota Chippewa tribe is a tribe, but then we also have our quote-unquote bands, reservations, having things like gaming compacts. And so I think this gets back to the unique structure of the Minnesota Chippewa tribe, but maybe you can say a little bit more about why our individual tribes, our individual reservations or bands are also tribes, and Minnesota Chippewa tribe is also a tribe, which seems confusing, but try to give us a little bit more.
Yeah, and I think the easiest way to describe that is that it's a symbiotic relationship, right?
Okay.
So the Minnesota Chippewa tribe couldn't exist without the individual bands, right? Right now, the way we're organized, the individual bands couldn't exist without the Minnesota Chippewa tribe. The question we have now is to what degree in the current constitutional reform efforts do we want that symbiosis to continue, right? I think there's really good reasons to have a very loose affiliation together as the Minnesota Chippewa tribe, whether it be a new thing such as an intertribal court of appeals or dealing with election appeals, things like that.
Right.
There's definite reasons to have the 41,000 members of our tribe together and being able to leverage that and really speak with a voice to not only counties and cities in northern Minnesota, but also to the state of Minnesota itself. that's one of the things going forward is in that one of the other hard things that will be distinguishing between those two and figuring out that relationship. But as a band member, I've always seen a value in providing clear authority to the RBC and clear limited authority to the TEC, whatever that is, but then maintaining that relationship. I mean, when it comes down to it, we have families and our friends at other reservations, and we're spread out through the state of Minnesota, but I think we are still very much connected.
Excellent. One final question sort of about law. Is the Constitution and bylaws, are they defined as tribal law?
I think they're the primary
They're
source.
governing documents.
They're the primary source of
Yeah.
tribal law. So the way constitutions are supposed to be, I mean, in the hierarchy of laws, they're supposed to be paramount. I think what we're missing right now is independent judiciary to help us really implement and tell us what these constitutional provisions, how they apply to our individual members. And that would be something in the reform efforts, as well as really think about how we can have a body that's independent from the current governing body, help us define what these rights look like and how we as people are protected by the document that's supposed to provide protection. If you think about in the U.S. system, a lot of the positive social developments that we've seen have been triggered by case law changes.
Yeah.
Brown v. School Board. Just think of all of the cases that have brought about huge social change.
Yeah, recent Supreme Court cases related to marriage, of course, comes to mind.
And that's taking the constitutional language and then applying it directly to an issue and coming to a result that's relevant and helpful to the current populace.
Yeah.
That's something that we're currently missing, and I think would definitely need to be addressed.
Excellent. Thank you so much. I've run us just a hair over time here. We've had many people logging on, watching parts, and coming back and forth, and I'm going to ask you to select 4 numbers between 1 and 77 of your choice.
Okay. We will go with 3 for my daughter.
Oh, lovely.
We'll go with, this is bad, 5 for the 6 for the number of years I've been married. We'll go with, I don't know how old you are, Mom. I'll be generous. 48 for my mom.
Okay.
She's in her upper 50s, but 48. And just a random one, let's go 65.
Excellent. Thank you so much. That's our unbiased, clearly random approach. So Lorna Lagoo is working on her end to get the gift cards out. And thank you so much, everyone, for tuning in. We could have several sessions talking about the MCT Constitution, and we really appreciate your being forthright with your opinions and sharing your vast wealth of knowledge with us this evening.
Yeah.
Thank you to everyone who has logged on with us tonight. We're working. We might have a session next week. We'll see. Otherwise, we know we'll be back May 8th when we're going to have Rebecca Webster, and she's going to talk about a little bit broadly about the Haudenosaunee and then about the Oneida in Wisconsin. We're going to move into some comparisons where we learn about other tribes. All of our sessions to this point have been about ourselves, so we're going to look outward a little bit as we move ahead. So keep your eye on our Facebook page for announcements about that, and check out zaagibagang.com as well. And Gigo Wabamin, thank you all for tuning in and listening.